H.R. 358 to amend the Patient Protection and Affordable Care Act to modify special rules relating to coverage of abortion.
Without objection, the first reading of the bill is dispensed with.
Reserving the right to object.
The gentleman is recognized.
Mr. Chairman, I reserve a point of order.
Gentleman reserves.
Mr. Chairman, actually, I make a point of order.
The gentleman will make his point of order.
Mr. Chairman, I make a point of order. Consideration of this bill is not in order as it has not been duly enrolled under the rules of the House and asked to be heard on the point of order.
The gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, as my colleagues know, when we began this new session of Congress, we enacted a new Rule 12, Section 7, subsection 5C1, that requires that all enrolled bills have a statement attached that state the constitutional authority under which the bill may be considered. And I can read from subsection C1, record a statement citing as specifically as practical the powers granted to Congress in the Constitution to enact the bill. When this bill was enrolled, when H.R. 358 was enrolled on January 20th, 2011, that statement, which was intended to state a specific section of the Constitution, fails to do so. As such, this bill has not been duly enrolled. I ask that it not be considered today and that the remedy be it be reintroduced with a proper statement and that the bill be considered at that time. The language that was included in the record reads as follows. Congress has the power to enact this legislation pursuant to the following, the Protect Life Act, which apparently is the short title for this, would overturn an unconstitutional mandate requiring abortion in the Patient Protection Affordable Care Act. Unlike every other bill that has been introduced in this session of Congress by Democrats and Republicans alike, no section of the Constitution is stated, no subsection, no constitutional authority whatsoever. It's as if someone said, we're going to be considering the bill because we don't like it or we don't think it's constitutional. The requirement of the rule is clear. It says it has to enact a bill, the power granted to Congress in the Constitution. None of this language refers to that, and I make this point of order for really two reasons. One is I think we should follow the rules. I think this is our first day, and I like that section that the Republican majority insisted upon. I think we should always be thinking about the constitutional underpinnings of what we do. Secondly, there's a serious question of whether, when push came to shove, you'd have the ability to point to where it is in the Constitution you could take a woman's right away, where you'd have to be able to say where under the Fourth Amendment you have the right to deny the right of privacy to half of the population of our country. And so for both of those reasons, I insist upon my point of order and the remedy that the bill not be considered on this day.
Would the gentleman yield for a minute? Can I yield?
Well, you have a right to be heard on the point of order.
Yeah, I was just wondering if you'd...
Sure, certainly.
The chair will recognize...
No, I would just talk about, in his debate on the protections of the Fourth Amendment, I think the Constitution will also start having a great debate about the constitutional rights of the unborn.
Well,
I mean, if we want to have a debate on when life begins, then
sure,
I think many of us are ready to have that debate.
I would welcome that because, you know, we have this dynamic that, frankly, most of the American people believe in a woman's right of privacy, and this Congress, in a majority, doesn't believe that.
I would ask the gentleman to cite the public opinion polls that would have the vast majority of Americans who believe that.
Well, I think we can go ahead and talk about public opinion polls. I'll be glad to swap them back and forth, but the rules of the House are fairly
You're the
clear.
one who quoted the public opinion and the percentages, so I'm not doing that. You're doing it.
I will stipulate that I come here not to have a conversation about the public opinion, and I apologize if that threw the gentleman off his step, but the rules are the rules, and I think the Constitution is the Constitution. If indeed there is a constitutional underpinning for what we do today, the rules should be followed. I'm holding in my hand the rules of the House. This is day one, markup one of this august subcommittee, and we have failed to do what's required under the rules. I think it's perfectly reasonable for you to say that subsection something or other. Let's introduce it properly. Let's get this right, and let's come back and do it that way.
The chair thanks the gentleman, and we'll pause.
Now, Mr. Chairman,
Mr. Chairman,
strike the last word.
Well, I think all members, point of order, I think all members have a right to
get
be
this
heard
right.
on the point of order.
If you would permit us to consult with the parliamentarian, please.
I think members have a right to be heard on the point of order, Mr. Chairman.
I'd like to be heard on the point of order, Mr. Chairman, if that wasn't clear.
The chair recognizes the ranking member.
Thank you, Mr. Chairman. Mr. Chairman, I believe, if I could follow up on what Mr. Wiener said, my concern is that the reason why the majority has not cited the Constitution is because they can't.
Yep.
In other words, Mr. Wiener is saying that the rule requires that the constitutional authority be placed in the record under the new Republican rules, and that they haven't done so. And I think the reason they haven't done so is because they can't. My concern throughout this debate on this bill starting Wednesday has been that basically this bill impinges on a constitutional right. In other words, under the Supreme Court decision in Roe v. Wade, women have certain reproductive rights pursuant to the privacy provisions that the Supreme Court ruled on in Roe v. Wade. And essentially what this bill does is override that in an unconstitutional way. So I think it's not only a procedural aspect that they haven't stated the law or the constitutional reason, but that they can't, which in my opinion makes it even worse, because essentially hide what they're really trying to do, which is overrule the Constitution. Now, I know Mr. Shimkus and others would probably think that that is a good thing to do, but the fact of the matter is the court hasn't done it. Roe v. Wade is still the law of the land, and if you're going to override it, then you're going to have to say that that's what you're doing. And there's nothing here at all, because essentially there's no ability on the part of the majority to justify this on a constitutional basis. So I think this is a very, very important point that Mr. Wiener was raising. It's not just the procedural aspect that you haven't cited it, it's the fact that you can't because of what you're really doing. And I would yield back.
Mr. Chairman?
Mr. Chairman.
Mr. Chairman, I would move to strike the last word.
Mr. Chairman, the chair recognizes the chair emeritus, Mr. Barton.
Thank you, Mr. Chairman. We have checked, and the information that Chairman Upton and I have just received is that when this bill was filed on the floor, the document citing the constitutional authority was also filed with it, so that we believe that we are in compliance with our new rule. We respect our friends on the minority by holding us accountable for the rule. If they are right, they are right, and we will live by the rule, but we are told that we have complied with the rule.
Would the gentleman yield?
Let me ask the council first to confirm what I've just said, and then I'll be happy to yield. Is it true that when the bill was filed on the floor and put in the hopper, that it did have the constitutional authority filed with it?
The chair recognizes the counsel for the committee.
Yes, sir.
There you go. Do we need to put the counsel under oath, or can we assume that he is telling the truth? I now yield to my friend.
Yeah, I just would perhaps, I mean, I can get you a copy if you like, or you or the council can point to the reference to the section of the Constitution in that section, in that statement. I mean, you can put my daughter has curly hair here. It doesn't mean that you've lived up to the rule. Now I'm going to read the rule again. Record a statement as specifically as practicable the power or powers granted to Congress in the Constitution. I don't see that here, Mr. Chairman Emeritus.
Well, would the gentleman from New York yield?
Well, reclaiming my time, we have a point of order. There is now, we have confirmed that we have filed the document. Now there is a question by the minority about the constitutional appropriateness of that document. That is a legitimate opinion, but I don't believe it is a constitutionally required fact. We have a difference of opinion about what we filed.
No, but Mr. Chairman, if you'll just yield so we don't misunderstand. I am not saying that there's a constitutional requirement that the rule be followed, but it's the rule of the House. And this is a point of order that the rules of the House are not being followed. And the rules of the House are unambiguous. It doesn't say you've got to file a statement. It says you've got to file a statement. And this is your rule, and frankly, I support it. I think it was a good idea. The Congress the granted to Congress in the Constitution. So you can file words and have answered your question, yes, Mr. Chairman Emeritus, but you will not be in compliance with the rule. And I would say, as you, sir, common sense, where does it say would overturn an unconstitutional mandate? Well, that's like saying I want to do this because it's constitutional.
Well, again, reclaiming my time, we've had two federal courts now rule that the law that we're seeking to amend is in fact unconstitutional. We've had, I think, two courts rule that it is. So the federal courts have various opinions about the constitutionality.
Well, the
It's
gentleman,
certainly within the right of the new majority in the House to take the position that the courts that have ruled it's unconstitutional are in fact the appropriate view.
but will the gentleman yield?
I don't know
The
if
chair
I still
is
have-
prepared to rule.
Well, I think that, I think gentlemen,
Mr. Chairman.
Chair.
Mr. Chairman, Mr. Chairman,
We have
Mr.
some
Chairman.
members, Mr. Chairman, that are striking the list. Or
No,
Mr.
the-
Kowski.
Mr. Chairman,
All right.
they're not amending anything.
Mr. Chairman,
The chair recognizes the ranking member emeritus, Mr. Dingell.
Mr. Chairman, you are most courteous, and I thank you.
Point of order.
It occurs to me that the best proof that the papers were filed would be the presentation of the papers here in the committee, and that they should accompany the documents that are required to be presented to the committee, including the language of the bill, as opposed to having a great foo-frow as to whether or not these papers were filed in proper form. Those papers best speak themselves to the situation, and if they are not able to be presented, I with all respect to those who've said they were presented, I would think that they should be presented to us so that we may then see them and observe, because this constitutes the best evidence. Now I'll yield to the gentleman from New York.
Well, and I just want to, an important part of that, Mr. Dingell, is they've got to show where in these words the Protect Life Act would overturn an unconstitutional mandate regarding the abortion in the Patient Protection and Affordable Care Act, where in those words it alludes to any section of the Constitution. That's the challenge here. The challenge is not whether this is unconstitutional or not. That, you're right, is subject to interpretation. Our rules put a burden on all sponsors to point to the Constitution and say, this section, this clause, this word. We failed on that. I don't think there's any real dispute on that. No one has yet to say, hold up a copy of the Constitution with these words highlighted or this section highlighted. The question isn't whether you're right or wrong about this bill. We're going to let the courts decide. We're going to let this legislature is going to work its will. The question is whether on day one we're following the rule which requires very specifically, it's unambiguous, it's powers granted to Congress in the Constitution. These words, there's no reference to that. Nor would it be if I would introduce a bill and say, because I think this is constitutional, right in front of the Health Care Act. You wouldn't be able to, you wouldn't accept that in a minute. You would never say, okay, that's good enough. You think it's constitutional. You'd say, where is it? What's the purpose of this rule?
Reclaiming my time, with all respect for my good friend from New York, he makes a very good point. But I would simply observe that the best evidence that the papers were filed in accordance with the requirement of the rules is the presentation of the papers. The papers will speak to themselves, and they will also define whether or not the contents of the papers met the requirements of the rule. And so I would urge that the point of order has to be sustained, and I thank you for your courtesy to me, Mr. Chairman.
The
Mr.
chair
Chairman.
recognizes the counsel and ask him if Mr. Wiener's point of order lies.
Before you rule, did Mr. Kowski want to be heard on the point of order?
I think there are additional members that want to...
We can have additional discussion. The counsel is recognized.
Wait, Mr. Chairman, point of order?
Yes.
The council's not being asked to rule on the point of order, is he?
No. Ask.
Well,
Chairman,
to Mr. Dingell's point, there's no requirement that the constitutional statement that was submitted along with the introduction of the bill be circulated in the committee before the consideration of the bill.
Can I direct a question to the council?
The gentleman, Mr. Wiener.
I don't. That is not the subject of the point of order. I appreciate that guidance about circulation or whatever, but I mean, it does. Well, let me ask the council. Am I correct that Rule 12, Section 7, subsection 5C1 reads as follows: A bill or joint resolution may not be introduced unless the sponsor submits for printing in the congressional record a statement citing as specifically as practicable the power or powers granted to Congress in the Constitution to enact a bill or joint resolution. Is that not the rule of the House?
Yes, sir.
Is there any further question to the Council? Is there any reference in this, what I'm about to read to you, a section in the Constitution? The Protect Life would overturn an unconstitutional mandate requiring abortion in the Patient Protection Affordable Care Act. The question is there any reference to a section of the Constitution in the words I just read?
No, sir.
Thank you, Mr. Chairman.
Would gentlemen yield quickly to me, if you please, gentleman from New York?
Certainly.
The best proof of what this filing, which was made supposedly in accordance with rule, is the content of the paper itself. And I would suggest that in order to resolve the question, and to see to it that we don't wander into this or flounder into this kind of a mess again, that the rule should be interpreted to see to it that we have the document so that the chair might appropriately rule, knowing what the particular paper happens to say. And no one in this room seems to know what the paper said, and there is some doubt as to whether in fact the filing was made. And I thank the gentleman for yielding.
Mr. Chairman. Will the chairman yield again to the Chairman Emeritus?
If I have the floor, I'll yield to the gentleman, of course.
I thank the distinguished gentleman from Michigan. I have a copy of the Constitution of the United States. I hope we can certify that it's a valid copy. Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Mr. Counsel, is it not true that the bill that has been introduced is a piece of legislation?
We'll stipulate it.
Yes, sir.
It is a piece of legislation.
Yes, sir.
Is it not true that a piece of legislation can amend an existing law?
Yes, sir.
Is it also not true that the bill before us is a piece of legislation that would amend an existing law?
Yes, sir.
So therefore, is it not constitutional that this bill complies with the rule of the House of Representatives?
Reclaiming my time, and with enormous respect for my good friend from Texas, I would simply observe that we all are aware of the Constitution. This is a matter which can be taken judicial notice of in any court. And I think that is so clear that we don't need to spend time on that. But the document that is supposed to comply with the rules and to support the presentation of the bill in accordance with the rules of the House is not before this committee. So no one in this room has the vaguest idea what that piece of paper happens to say. And until we have seen it, we can at best only speculate, A, whether such paper exists, and B, whether it complies with the rules. And with all the respect I have for the chairman of the subcommittee, I would simply say that even with his great wisdom, without having seen the document, he can't tell us what it does and whether the document is in compliance with the rules.
Mr. Ding, would you yield for a brief moment?
I will, yes.
If I can just...
The chair is prepared to rule.
I think members...
Mr. Chairman, we have additional questions on the point of order. We have to have debate on the point of order.
Right, let the council respond then, please.
The requirement in the House rule to submit the constitutional statement is not appropriate for a point of order. It is appropriate for debate during the committee's deliberation.
Okay.
Would the gentleman yield on that point? I mean, can I follow up on that point, Mr. Chairman?
The gentleman is prepared to rule.
Mr. Chairman, I've been having... Mr. Chairman, I've had my hand up.
We will have further debate on this. The chair is prepared to rule.
Mr. Chairman, point of order.
The gentleman will state his point of order.
Members, is it not... the members have a right to be heard on the point of order under the rules of the House of Representatives and the rules of this committee. And I think that Ms. Schakowsky, at least in the council, just said that violation of the rules are not a point of order, which is, of course, not only counterintuitive but wrong. But I think at very least members have a right to be heard under the rules of the House on this point of order. And Ms. Schakowsky at least, and I know others, are waiting to be heard on the point of order. This is the most unusual transaction. The counsel asks the questions, then he runs and answers them.
The members have a right to be heard. At the chairman's discretion, the chairman may entertain as much or as little debate as he wishes. The chair is prepared to rule.
Mr. Chairman, if we don't have, point of order, I'd like to be heard on it. It's my interpretation that this bill is not properly before this committee.
Mr. Chairman,
Mr. Waxman, recognize the gentleman. The chair is prepared to rule.
Mr. Chairman, I would request a chance to speak briefly on this. I have a feeling your mind is already made up, but I would like to bring something to your attention that might make you look at it in a different perspective. And I'd ask for 2 minutes.
We'll recognize each side for 2 minutes, and then the chair will rule. The gentleman is recognized for 2 minutes.
There's a rule that was adopted by the Republican majority that said we had to say where in the Constitution the legislation that's being introduced fit. And that's the rule. And what the Republican proponents of this bill put in as their justification is the following, and Mr. Dingell said that ought to be circulated, but we could read it, that Congress has the power to enact this legislation pursuant to the following. The Protect Life Act would overturn an unconstitutional mandate regarding abortion in the Patient Protection and Affordable Care Act. Now, I don't know what the unconstitutional mandate is. I don't know that members of Congress can decide that there was an unconstitutional mandate. No court has reached that conclusion. The court has reached, one court has reached the conclusion that a mandate to buy insurance may be unconstitutional, but there's no mandate regarding abortion that I've ever heard argued. So if this is the justification, it makes a mockery of the rule that the Republicans have introduced that you must say where in the Constitution. If we're following the Constitution, it's so important we have to show where in the Constitution there is a justification for the bill, then okay, let's follow that rule. I just don't see that this statement, this paragraph, meets that requirement. Now, it may well be that a point of order can't be raised against the bill's consideration because of a failure, to state the constitutional provision. That may well be the parliamentarian's point, but it's hard for me to see that that in other bills we saw Ms. Richardson introduce a bill, and this is granted a power under Article 1, Section 8, Clause 3, and Mrs. Blackburn introduced a bill acting pursuant to the power granted to Congress under Article 1, Section 8, Clause 3, and Ms. Fox cited another constitutional authority, but the only authority in this bill, for this bill, is a statement that the law should be overturned because of the presumed unconstitutional mandate. It doesn't say where in the Constitution this law would be justified. So I make that point to further express some views, the Chairman, to take it under consideration.
Chair, thanks, gentlemen. Chair recognizes the gentleman from Georgia, Dr. Gingrich, 2 minutes.
Mr. Chairman, thank you, and this is inquiry of counsel. Counsel, it's a pretty straightforward question. Is it constitutional for Congress to submit legislation such as this seeking to amend a current law that it deems to be unconstitutional?
Yes, sir.
Would you repeat that?
Yes, sir. So
in your opinion, is this point of order challenging that? Is it subject to a point of order? Mr. Counsel, would you answer that?
It is the chairman's decision. I have very strongly held views on it.
And I thank you for that. I think I understand exactly what you said.
Would the gentleman in Georgia yield to the Chairman Emeritus and the majority briefly?
I'll be glad to yield any time remaining to the Chairman Emeritus.
Commend Mr. Weiner for raising this. I think it's an important debate to have, especially since this is the first markup of a subcommittee of this committee. I want to commend Chairman Pitts for allowing there to be a discussion It is at the discretion of the chair to rule on points of order. The normal tradition of the committee has been that each side gets 5 minutes to make their point of order and then to rebut it, and then the chairman rules. But because this is a constitutional issue and it's the first time, I want to commend Chairman Pitts for allowing there to be more extended debate. But on the specific point of order, what Mr. Wiener's real argument is that our constitutional citation to comply with the House rules was not done as artfully as it should have been done, or maybe not done exactly like he would have done it. That's his opinion. But the fact is, we did put that in, and it is definitely constitutional for an authorizing committee to amend a current law, repeal it, change it, whatever the committee wishes to do in introducing those members of the committee to introduce the legislation. And this clearly complies with the constitutional authority granted in the Constitution to the House of Representatives. So I would urge the chairman to rule against the point of order because it is without merit, although it is meritorious in the fact that we are having a debate that needs to be had.
Mr. Barton, would you yield?
I yield to Mr. Whitfield.
His time has
The
expired.
gentleman-
I've been
Gentleman's
trying to
time has
speak.
expired. The chair is prepared to rule.
Mr. Chairman, can I just ask, I don't understand what you're ruling on because we have additional members like Ms. Schakowsky that would like to speak on the point of order. And Mr. Whitfield, I mean, you shouldn't be cutting off debate on the point of order. If there's debate on the point of order, members should be continued to allow to talk about the point of order.
All right.
I'm just simply saying, Mr. Chairman, that there are additional members that want to speak on the point of order. They should be allowed to speak. I don't understand what we're cutting off here or why we're ruling if there's still members that want to talk about the point of order. And Ms. Schakowsky has made that request.
Is the chair asked the council, is the debate debatable under the 5-minute rule?
Yes, sir.
Mr. Chairman, can I ask the council a question? I just want to make sure that we understand. I'm not talking about the adequacy of the statement in the light of whether we view it's constitutional or not. That's not the issue. It's the issue whether it's in conformity with the rules of the House. It might be constitutional, it might be unconstitutional, but if we are to accept this statement as in compliance with the rule of the House, then simply put, I can write on the next bill I introduce because I think the present laws aren't good and constitutional. That's it. That's the problem. You're in violation of the House rules, not whether or not the bill is constitutional or not. You may be right. You might be wrong.
Would the gentleman yield? Would the gentleman from New York yield to me?
Certainly.
I thank the gentleman. Gentleman from New York, I think the council has already responded to that inquiry, saying that the rules of the House in regard to submitting a statement in regard to the constitutionality of this legislation was submitted. Is that not right?
No, reclaiming my time, that's the wrong question, I said, my good friend. The question is whether it was submitted. I don't dispute that it was, but I can tell you it does not conform with the clear letter. It says here the powers granted Congress in the Constitution, and I can bring the gentleman a statement. It doesn't refer to the
chair thanks the gentleman. The chair's been more than generous with the time for debate. The chair
Mr. Chairman, I have had my hand up for the last 20 minutes.
Mr. Chairman, can I just ask, with regard to additional debate, Ms. Schakowsky and anyone else who wants to debate this issue should be allowed to do so. And I'm not quite sure I understand what the chairman is ruling on. Will members such as Ms. Schakowsky be allowed to continue to debate the constitutionality issue?
In the opinion of the chair, he has been more than generous with both sides on the debate on this issue. The chair thanks the gentleman, but is prepared to rule. The chair rules.
No, I would like to raise a point of order before the rule.
She's requesting to speak on a point
Chairman,
of order,
unanimous
Mr. Chairman.
consent.
The chair
I
has
ask
ruled.
unanimous consent that the
point
debate
of order does not lie, and that is the ruling of the chair. Members
All right, now
can
can
debate that under the 5-minute rule.
So, Mr. Chairman, point of order again. Are members such as Ms. Schakowsky and others allowed now to continue to argue over this constitutional issue? Is that still allowed? It should be, it seems to me. Can we continue that debate?
Yeah. As soon as the bill is up for debate,
okay.
they have 5-minute rule, and they can debate.
A point of parliamentary inquiry, Mr. Chairman.
Gentlemen, state his
Members who use a portion of their to discuss the rule, the point of order on the rule, will then be denied a further 5-minute a section of time in order to consider the substance of the bill. Isn't that true?
And point of order.
The chair will follow the rules of the House, and each member will have 5 minutes for the debate.
But point of order, Mr. Chairman, even though...
The gentlelady will state her point of order.
If this is debatable, even though the ruling has been made, and I wanted to make a comment on it, are you saying that you will shut down debate on this very important question at the first markup of a bill? Now, whether or not members get a chance to actually debate the constitutional, that whether or not you follow the rules of the House, is this the way we're going to operate from now on? That counsel is going to give a one-word answer, yes, that he's going to use all kinds of subterfuge, that he doesn't have to circulate the information, that it isn't a legitimate point of order. This is very important. Is this the way you're going to run this committee? You're just going to decide whether or not the rules of the House apply here, because I think this is extremely insulting, and I think the American people who are watching now feel that manipulation has been used to shut down debate.
Chair will ask the gentlelady to state her point of order.
The point of order is, I believe that I have a right to speak under the rules of the House. And under the rules.
Mr. Chairman, inquiry. I would simply ask that each member be given 5 minutes to strike the last word and discuss this issue of the constitutionality at this time, if we could. I think, without prejudicing their right to speak on other issues. In other words, that we should simply allow each member to strike the last word for 5 minutes on this issue of the constitutionality under the rule. That's my request. I'd ask you not to make that request.
I'm going to object to that. The point of order has been ruled on. We're now under the 5-minute rule in the debate.
But the point is that we weren't members weren't allowed to speak on the point of order. They should be allowed to speak on this issue of the constitutionality rule. And I'd simply ask the chairman, I'm not asking for unanimous consent, simply asking the chairman that each member, if they choose, should be able to spend 5 minutes on this issue, those who have not had the opportunity.
And I reserve the right to object.
The objection has been heard.
Order. Point of order. The gentleman from Illinois reserved the right to object. She has an opportunity to speak under her reservation.
She's not objecting to anything.
She reserved the right to unanimous consent request.
The chairman has said everybody's going to have 5 minutes to speak.
Point of order.
The chairman has ruled.
Point of order. Point of order.
The chairman, under the rules of the House of Representatives, has the right to make the decision on the point of order.
Mr. Chairman, there is a unanimous consent request. There is someone who is reserving the right to object to it. She gets to speak to her reservation.
I object to the unanimous.
It's too late. It's too late. The gentleman does not control the floor. The gentlelady from Illinois has a reservation that she has a right to speak to.
Mr. Chan, I'm simply asking that members be allowed to strike the last word exclusively on this issue.
And I reserve the right to object.
Mr. Chairman.
The gentleman will suspend.
Yeah. And Mr. Chairman, I find it interesting that every man has spoken who wanted to on an abortion bill that only affects women, and I would like to object. I have objected, and I would like a chance to speak. Sure. I reserve to object.
All right, without objection, the first reading of the bill is dispensed with, and the bill will be open.
Reserving the right to object. Reserving the right to object.
Gentleman's recognized.
No, I object to the not reading of the bill because we have yet to determine whether or not the bill is even properly and duly enrolled. There's a reservation that from a unanimous consent request that is still outstanding. The gentleman was not in proper order. He no longer controlled the floor. The gentlewoman from Illinois, under a proper recognition and proper reservation, has a right to speak under her reservation to unanimous consent request. The gentleman from New Jersey was properly recognized and controlled the time. The chairman does not have the right to take and give control of the time willy-nilly. There are rules under which we operate.
Mr. Chairman, if the gentleman will yield.
I don't control.
If the chairman will yield.
Or the chairman yields
surely,
to the
surely
chairman of the committee.
We've contacted the Rules Committee this morning, and they have sent this message back. So let me read this into the record. Clause 7 of Rule 12 requires a statement of constitutional authority to be submitted for printing in the record at the time of introduction of a bill or joint resolution. The point of introduction is the only point at which the rule is enforceable. The question of whether the statement is sufficient is a matter for debate and a factor that a member may consider when deciding whether to support a measure. There is no separate point of order in committee or on the floor relating to the sufficiency of the statement.
Reclaiming my time.
That is from the rules. So at this point.
No, I understand, Mr. Chairman. So we're reclaiming my time. The question now
the
is.
Gentleman will suspend.
Sure.
Continue, please.
So that is, we've heard from the rules. So at this point, I would suggest the chairman has made the proper judgment as it relates to the point of order. We need to get into the to discuss and debate the amendment in the nature of a substitute, and at which point all members then operate under the 5-minute rule. They can comment upon the gentleman's motion from New York. They can comment on the bill itself. They can comment on the amendments as they are offered. But I think we're now prepared to go, particularly that we've now received
reclaiming my time
back from the House Rules Committee.
We're reclaiming my time, and I appreciate the gentleman getting that ruling from the Republican-controlled Rules Committee. And frankly, it's completely appropriate for you to have that statement. The point now on the floor is whether or not all members have a right to their question about clear interpretation of the clear letter of the law. And what we're having now is the chairman is now saying, you know what, no, we've heard enough. And I think it's fair that on something as important in this, members have a right to be heard. Furthermore, continuing to reserve, Mr. Chairman, furthermore, we had something on the table that was in order. The gentleman from New Jersey made a legitimate unanimous consent request under proper recognition. There was a reservation of a right to object by the gentlewoman from Illinois, properly recognized to do so. She now has an opportunity to speak to that reservation. So we can't keep trampling on people's rights to speak here, Mr. Chairman. I just don't think it's an appropriate way to begin.
Will the gentleman yield to me?
Certainly.
The gentleman's time has expired.
First of all, Mr. Chairman, there was no provision under the rule. A reservation does not have a fixed amount of time. Furthermore, the clock was off. Third of all, I yielded to the gentleman from Michigan. So I don't see that my time has expired at all.
Mr. Chairman, I did have a unanimous request, consent request, and my concern is, as Ms. Schakowsky has said, is that the chairman allowed other members to speak on this issue and then ruled, and some people like Ms. Schakowsky were not allowed to speak. So my unanimous request, consent request simply is that other members be allowed 5 minutes to address this constitutional issue because they didn't have a chance.
And I can
reserve. And that not count towards their 5 minutes.
Mr. Chairman, I object to the unanimous consent request. If we're going to play by the rules, let's play by the rules. The chairman has the power of recognition. He has not recognized the gentleman from New York, and I didn't.
And he didn't recognize you either.
That is also true. He has not recognized me.
Without objection, the first reading of the bill is dispensed with.
Reserving the right to object, Mr. Chairman.
And
you just said without objection right after I said I reserve the right to object.
The bill will be open for amendment at any point. So ordered. The chair recognizes himself for the purpose of offering an amendment in the nature of a substitute.
Point of order,
Ask
Mr.
the
Chairman.
clerk to report the title.
Point of order, Mr. Chairman. You asked unanimous consent and there was an objection.